Okay, welcome to this IconS New Scholarship Showcase. Very pleased today to be featuring a book by Daniela Alaattinoğlu, who is joining us from the University of Turku in Finland. The book is called Grievance Formation, Rights and Remedies, Involuntary Sterilization and Castration in the Nordics, 1930s to 2020s. So Daniela, thanks very much for doing this and for joining us. And it's a terrific book, so congratulations on that. Could you just tell us a little bit about it? Just give us an overview and what the main claims are?
Yes, so thank you very much for having me. It's really a pleasure to be here. The main claims of the book and sort of the main context of the book, I advance three main arguments throughout the book. So the first one is that the international human rights law framework has provided master frame, but a weak master frame to conceptualize involuntary sterilization and castration, and that this affects how it is conceptualized also in the countries that I look at specifically. So Sweden, Norway, and Finland, and it affects the conceptualization both in a legal sense and a remedial sense. So what kind of remedies are given to victims. The second argument that I advance in the book is that apart from being used as legal instruments, the notion of rights has also provided victims with sociocultural entitlements, which has been very important for them to form individual and group identities in some cases, which has then affected their access to public recognition and institutional recognition as well. So that is the second argument. And then the third argument that I make is that the concept of grievance formation is helpful if we want to understand better how diverse forms of recognition and remedial responses have formed by different states then in or for different victim groups. As you might understand from this third claim or this third argument that I'm making, the states have responded very differently in terms of legal recognition, in terms of remedies to the different kinds of victim groups. And I wanted to understand why, and then traditional legal tools didn't really give me the sufficient answers to that question. So that's why I'm using the concept of grievance formation and developing it. So that is also the third argument of the book.
Great. Since you touched upon it, maybe you can say a little bit more about your methodology.
Yes.
Because as you say, at one level, it's a kind of doctrinal legal analysis, but it's a lot deeper than that. You do some field work, you draw on some sociocultural theory. So could you just tell us sort of the different layers of kind of the methodology you used?
Definitely. So as you say, I'm using a layered methodology, and I was inspired by what Hilary Charlesworth describes as feminist methodology, and talks about the need to sort of unearth different perceptions and different assumptions. And she says that it's similar to an archaeological dig. So I found that something quite appealing. So I understand the law in many different ways in these different layers that I will explain to you. So I'm understanding the law both as a way to regulate social life more in this top-down way, but also as a tool that can be used by people as an actor and as an expression, which has then been used to create individual, common, and public identities, and to provoke a state response, or in some cases not. So the first layer I'm using is a black letter law, basically, or black letter legal analysis. So in the first layer, I'm asking what rules and principles apply to involuntary sterilization and castration at different times. So that's the first layer, sort of the a layer that we as lawyers are quite familiar with. But then the second layer I'm using is a legal historical layer. So I'm taking in this historical lenses and asking how the law has developed in a historical context. So because I am starting from the 1930s and going on to, well, more or less to today's date, or 2023 are the last developments that I cover in the book. I also needed this historical layer to understand better the legal developments in their context. The third layer that I'm using is a socio-legal layer, where I am asking how the law is used and by whom it is used. And I'm also asking who is not using the law and how is it not used. And in order to get more information about this, I conducted 83 interviews with 83 informants. They were key informants, sort of in-depth interviews. So they have provided me with a lot of very, very rich material that only a small part of actually goes into this book, but it definitely has helped me to understand the context much, much better. And then the final layer, the fourth layer, is a comparative layer. So in order to understand the different reactions by the states and regarding different victim groups, I'm asking how we can understand the similarities and differences between the countries and the groups in context. So I think the comparative layer really it comes sort of last as the last layer, but it is very crucial in my analysis in this book.
Terrific, thank you. As a comparative person, I'm going to ask you about the comparative layer in a second. But before I do that, I forgot that I didn't mention the publisher, which is Cambridge University Press. And I also want to say, for any early career scholars or people writing their first book, if you have access to Cambridge Core and you don't have time to read this entire book, read the first chapter, because Daniela does a really excellent job laying out these different layers. I really found it extremely clear and accessible, considering how complex it is. I think it's a really good model for people to follow. But the comparative analysis. Can you tell us a little bit about why you picked sort of these three Nordic countries? Sort of why not say Iceland? Why not say other European countries? And also maybe this is an opportunity for you to expand on something you said earlier, which is that they sort of had different approaches, especially at the remedies stage in recent years. And so maybe you can also tell us kind of how they sort of diverged in their approaches to these issues.
Yes, thank you. Thank you very much. That's an excellent question, and or maybe a couple of questions. So I'll try to answer them all. So yes, I think this sort of very much also relates to why I decided to write the book. But yes, I chose the three countries, Sweden, Norway, and Finland, based on the most similar model, as also developed by Rehan in his book Comparative Matters. Sort of, we have these three quite similar countries that have had similar policies. So I'm looking into how laws and practices of surgical sterilization and castration first became established, abolished, and remedied. So I saw that there were similar in three quite similar countries when it comes to sort of geographical location, policies, the welfare state. So in many ways, quite similar, and also have had quite similar sterilization and castration policies, then targeting especially three main groups. So I start with these historical sterilizations that's starting from the 1930s to going on to the 1970s that target different kinds of marginalized groups, but especially poor women, I think is maybe the main poor and marginalized women is the main category within that group, but also to some extent ethnic minorities and poor people. That's the first target group that I'm looking at. So the historical sterilization and who they targeted. Then the second group I'm looking at is the people that were castrated. So that is a slightly different group, also starting around the same time period really as the first. So 1930s, 1940s, going on until 1960s, 70s. And that is something I broadly refer to as the people that are considered sexually deviant. So it is both sexual offenders, there are sexual offenders in that group, or people considered sexual offenders at the time, but also people that were just considered deviant in some way when it comes to their sexuality. So, for example, in Sweden, even though same-sex sexual relationships were decriminalized, homosexual men especially were targeted by castration policies and by being institutionalized, and castration could be used as a way to get released from institutionalization. That is, of course, not a voluntary form of castration. And then the third group I'm looking at is a more recent group. I'm looking at trans people and the use of sterilization and castration as precondition to get legal gender recognition. So in order to be able to change the legally registered gender in the population registry, in all the three countries, trans people have had to get sterilized or even castrated. So noticing that we have these three similar countries with similar policies, I noticed that the responses to the victim groups and the remedies given were very, very different. So we've had, for example, in Sweden, maybe the most comprehensive in the comparison, giving remedies to the first group and the third group, so the historical sterilizations, and also more recently trans people. And then Norway giving some remedies, and Finland, in Finland there is this kind of silence and really no remedies to anyone at all. And I just found that this was really interesting, that the responses could vary so much from state to state, especially as the discussions often influence each other in these in the Nordic countries. So mass media scandals in Sweden, for example, tend to be reported in Norway and Finland too. But the state responses were very different and varied also very much across time and from one victim group to another. So I found that comparison there is really a way to I think to unfold what has happened and try to understand how this came to be.
That's great, thank you. And could you just say a little bit more about what accounts for that difference? I think you kind of sort of get into some sort of cultural and historical factors for why Finland in particular is maybe a bit averse to these kinds of remedies, certainly compared to Sweden, but it sounded like even compared to Norway.
Yes, definitely. So, of course, this is something that I look more into in the book, and especially I think chapter 6 here is especially important to understanding that. But I'm using the concept, primarily the concept of grievance formation and developing that, trying to understand sort of what has been understood as a wrong and what has been understood as a right. So which groups have mobilized, groups have, or which individuals have mobilized, which groups have started to mobilize and build an identity as rights holders. How have the states responded to that? So I'm looking into sort of individual identities, and then how rights have been used to create individual identities and common identities among victims, but also how there is public recognition, particularly in mass media, and how this has been reported, how these practices have been reported, so how their public is or how in the public these practices are referred to as rights violations or not. Because at some points they are not referred to as such. For example, the sterilization of trans people in Finland as late as the beginning of the 2010s, so not too long ago, were sort of depicted in almost as a joke and not as a serious human rights concern. And I can see that this has developed a lot following mass media reporting. So going from saying that, oh, trans men can give birth and depicting that as something hilarious, it is more and more, or it was more and more framed as this is a serious human rights concern. Finland is one of the few countries in Europe that still require trans people to get sterilized in order to get legal gender recognition. So public recognition and validation of these claims is important, but also also state validation and state recognition of these claims made by the group. So at some point, and then using grievance formation to understand it, at some points state tend to respond to victims mobilizing. So certain groups of victims started to mobilize, for example, trans people, as also the most recent group that is maybe the most logical because we have the most developed human rights framework at the point, or at that point. So at some point, states have responded and said that, okay, yes, these practices are human rights concerns, or they are problematic. They refrain from saying that they're violations of human rights because of course, then that entails legal responsibility for the state. But they then, especially when it comes to these groups that I am looking at, they also develop these compensation schemes for some groups based on what they refer to as ex gratia, or the solidarity with the victims, or based on sort of the goodwill of the state, but which is clearly then motivated by these the earlier mobilization and also mass media reporting.
That's really fascinating. Could I switch gears a little bit to ask you about sort of why you wanted to write this book and a little bit about your intended audience as well? So were you aiming this at fellow academics? Were you hoping also to get the notice of governments or policymakers?
Yes, so I think yes, why I decided to write it again to understand better the different responses and really to unearth these developments. I think it is mainly mainly a scholarly book, and I think I hope that it can also have an impact outside of the outside of academia and the world of universities. But I think primarily this is a scholarly book for scholars that are interested in comparative law, socio-legal studies, law and gender, and rights in context. And I think especially that grievance formation and the theoretical and methodological tools that I use could be interesting to other scholars. Then when it comes to the world outside of academia, which I think is very important, and I hope that the book is interesting also outside, I think it is mainly targeting civil society, and I think that it is of some public concern as well. I think it is, of course, for anybody who wants to know more about involuntary sterilization and castration practices in the Nordics, and particularly how they were abolished and remedied. But I hope that it also can give some notion of the rights claims that can be made in this context, that it can provide maybe some legal arguments for civil society actors or human rights defenders in other contexts that are looking for inspiration to challenge similar laws or practices. And I recently discussed this book actually in Norway at a trans rights defender organization called FRI, F-R-I. And there they also said that many trans rights defenders are asking us about what happened in Norway and how were you able to establish the new law on legal gender recognition. And they said, this is great to have this book because we can give it to them and show them what happened. So in one way, it is also sort of writing the history of what happened from a legal perspective, of course, but just focusing on not just the establishment of the practices, but especially the abolition and remedies for the groups, because that has also not really been done before. So those are my main hopes, I think.
That last one is especially, I think, nice to hear, in that, you've done this like good, deep scholarly work. You've uncovered a history that hasn't been told. And that's not usually the kind of thing we think of as being useful to activists. But as you say, it can be, because they need to have the context to be able to make the claims now, right? And to be able to sort of educate people through civil society forums of various kinds. So that's really nice to hear. Could I ask now a little bit about kind of how this fits in with other scholarship in this area? So have there been books like this written on other parts of the world, maybe even single country studies? Or so I'm assuming, maybe I'm wrong, I'm assuming this is the first book of its kind to be written about the Nordic states, but I'm wondering if there were models or at least sort of somewhat similar treatments of these issues in other countries that you looked upon when you were writing this.
Right. So I think that is a very, very good question, and my answer would be yes and no, because there are single country studies to some extent in other contexts. For example, I think both the US context has been investigated to a certain extent by several authors. Also, the Canadian context is covered by scholarship so far. But in a way, I think that scholarship on sterilization practices tends to be historical, and with the focus on the what happened in history at the time, also maybe locating these practices a bit more to the past. So in a sense, my book is also a bit different because it looks at these practices going on to until today's date. A book that has been important for me in getting ideas was the book Eugenics and the Welfare State. Norway, Sweden, Denmark, and Finland. It's a book that was edited by Nils Rolf Hansen and Gunnar Broberg. That was very inspirational because it's also a historical account of how the first sterilization laws in the Nordic countries were established, and also a little bit about how they were implemented. But in this way, my work is also original because I do take this establishment into consideration, and especially the legal arguments going into it. It is so it's both original in a way to use this legal approach. I am also I think doing the really first systematic analysis of international human rights law and how international human rights law has conceptualized and remedied involuntary sterilization and castration that has not really been done before. My work, so my work in the jurisdictions that I'm looking at, I'm focusing on abolition of the laws and practices and remedies to victims, and that I believe is also very original because I haven't really seen any other scholarly work focusing on that. It is normally focusing on the establishment and the implementation of these practices. I think that is quite original, and I'm also looking at sort of with this broader perspective that I'm using, so different jurisdictions and different groups. I'm also able to take into consideration then the changing legal cultures and the changing notions of rights and how they actually play a part in this development, both in a legal sense, but also in a more sociocultural sense. And I look at two under-researched groups, really the castrated, the involuntarily castrated, and castrated or sterilized trans people. I think those have also not been covered very well by current scholarship, and the focus is normally on the historical sterilizations whenever there are accounts of this happening, which is of course also an important story to tell. It is often told in the context of eugenics. Eugenics is also a part of the background to this book, but I wanted to do something different and look at how this sort of goes on until today, and with the legal focus and really thinking about how rights have developed and how the notion of state responsibility has developed in these three countries especially, and also how international law plays a part in that development.
Yeah, it's very original for sure, and lots of different novelties, as you say. I'm not an expert in this field at all, but it did strike me when I was reading it that whenever I had read about eugenics before, it was always in historical treatments, always. It's always about like, this is the way the American South influenced Nazi Germany and so on, and various thinkers in the early 20th century. But yours is the first book that at least I've read that sort of sets that as context and then brings it into the present to show sort of the remnants of that regime and that thinking even today. So I think just that alone is really a really valuable contribution. Can we switch to talking about your process a little bit, Daniela? I mean, obviously, this was a ton of work to do this book. Can you tell us what was challenging, maybe the most challenging part, also what was rewarding about it?
Yes, thank you. I think that the most challenging part, if I start from that question of writing and doing research, I think that it was perhaps especially that this data that I gathered, which also took a very long time to gather, and involved a lot of field work, going to different countries and interviewing people, so that I had this very, very rich and complex data from 3 or even 4 jurisdictions, because also the international human rights law
Right.
is part of that. I had primary and secondary sources. I had a very, very vast interview material, and I was trying to figure out for quite a long time, how do I compare these very complex differences, and how do I do justice to all this data and present it in the most conducive way, really. So I think deciding the story that I wanted to tell in the book was maybe one of the most challenging things in the process of writing it. And I think it was also from this book is based on my PhD thesis that I did at the European University Institute. And part of rewriting the PhD into a book was really about foregrounding the story that I wanted to tell more clearly. And sort of going from having my eyes on all the details to seeing the bigger picture. I think that was maybe the most challenging part. And then when it comes to the most rewarding part, um, it is kind of the same in a way, because I think that doing the field work, conducting the interviews, and meeting the people involved and the people that had. So I'm interviewing, or I have interviewed both civil society representatives, state representatives, academics, journalists, so from quite different groups. But I really enjoyed the personal encounters, and I think it really made me understand the issue much better, and how important these issues were to many people. For example, when I met the public interest lawyer Kerstin Burman in Sweden, who has engaged in strategic litigation to abolish the earlier sterilization precondition, and then to get compensation for those sterilizations, and for those victims to access remedies. When I met her and talked about her decisions whether to use the European Convention on Human Rights, which she knew that this is a very sensitive issue in Sweden, because Sweden has a national legal culture where human rights are not really, they didn't really used to be common in strategic litigation. And strategic litigation, in fact, didn't used to be very common at all in Sweden, and the same in the other Nordic countries. And sort of thinking about or hearing about how she thought and reasoned whether to invoke the convention or not, and sort of what reactions that could get. I think that was really, really interesting to hear more about that. An exciting part was also the some of the archival work I did for this, quite limited archival work, accessing some old court cases and analyzing them legally, which had not really been done by other lawyers, or at least other contemporary lawyers before, but only by historians. And I think that was really exciting, because I could, of course, as a lawyer, see different things that historians would not maybe pay attention to so much. And I really enjoyed that part. And then I think also comparison. I would say that the comparison, even though it was very challenging, it really made me discover things I would not otherwise have noticed and problematized. And I think that is also even though comparison is very difficult to do, I think it has been so rewarding in this case, because if I had stuck to just one jurisdiction, I think I would not have seen certain things. So I started problematizing, for example, seeing that in Sweden and Norway, there is a tradition of remedies to some groups. So they had sort of this modern remedial culture developing since the 1990s based on ex gratia, with reference to some groups, but not others. But this had not happened at all in Finland. And I started just wondering why. And I noticed that this has not really been problematized in Finland, because nobody had done this comparison or questioned this from a legal perspective before. So I think that was really, really rewarding as well.
Yeah, I think that's one of the good things about comparative work, is that it uncovers some of the assumptions that you have about your own system more than anything else, right? And so, yes, it teaches you about other places, but it actually ultimately teaches you about where you are and the things that you've sort of taken for granted. A related question, I guess, I think maybe this flows on from some of the exciting things that you did. Do you have any advice for, people writing their first book, especially, I'm sure there'll be folks listening to this who are currently doing PhDs or who are in the process of converting their PhDs into a book. Do you have any advice on how to do that and things they should keep in mind?
Yes, so I think that is also an excellent question, and difficult to sort of think of one piece of advice I could give. But I think as an early career scholar and for early career researchers in general, I think it's quite common to have some kind of imposter complex, or some kind of the imposter phenomenon is quite can be quite widespread in this group, and comparing yourself to more senior academics, it can be sort of quite daunting. How can I write something that matters and that will be read by others? So I always try to think of the positive side of the imposter phenomenon, which is that when you do research and you write something, you do it well, and you do it very carefully, because you make sure that all your claims are supported by evidence. Because well, they should be, but you're, of course, I think when you you have this idea that everybody does this better than you, then you do actually do the research very carefully yourself, and you make sure that it's thorough. And I would say that it's important to not be paralyzed by unhelpful thoughts that comes with imposter phenomenon, and try to establish a working routine, really in a practical sense, that works for you. And I think that for scholars, many times, that genius is really diligence.
It's really good advice, especially the taking the anxiety that we all have and trying to channel it in a productive way, because you're not going to get rid of it, right? So might as well use it for something good. Final question. I mean, you mentioned that you actually had, a lot of data that you hadn't used for this book. So is there another book coming? What are you working on now, or what's next for you?
Yes. I think, well, next, maybe not directly on involuntary sterilization and castration. I think I'm taking a bit of a break from that specific topic at the moment, but I am trying to further develop the field of legal mobilization. At the moment, quite a lot of the scholarship builds on strategic litigation, and I'm trying to use legal mobilization and think of legal mobilization in a broader way, and try to think of other ways people mobilize in a legal way, but also, very importantly, the silences and why people do not mobilize, which I think is an important part also of this book. So part of my work, or ongoing work, is about strengthening this bridge between legal and social movement scholarship that exists at the moment. And I'm trying to think especially about the concept of legal inclusion and exclusion in a socio-legal way, but also in a comparative and historical context. So which groups and individuals are included by legal systems and which groups are then excluded by legal systems, and trying to understand more about the mechanisms behind legal inclusion and exclusion. That is what I'm working on at the moment, and I find that also quite exciting.
Yeah, it's a big project, very theoretical. Terrific. Well, Daniela, thank you so much. Really enjoyed the conversation. And yeah,
Thank
good luck with the big project coming up.
you. Thank you very much. Thank you for having me.